Today, we're going to discuss how to get green cards for parents of United States citizen children. Essentially, there's three issues that we're going to be discussing. One is, what are the requirements for the U.S. citizen child trying to immigrate their parent? Two, where is the parent living? And three, if the parent is living in the United States, how did they enter the United States? Let's begin. The first issue is, what are the requirements for the child to immigrate a parent? Well, there's essentially only two. One, the child must be a United States citizen, and two, the child must be 21 years or older. What that means is that a permanent resident child cannot immigrate their immigrant parent for permanent resident benefits. However, there's an easy solution. That child could become a naturalized citizen. They could apply to become a citizen, and when they become a citizen, then they can apply for their parents to obtain a green card. The second issue needs to be combined with the third issue because they really go hand in hand. And that's, where is the parent living? And if they're living in the United States, how they entered. So we're going to explore three situations. The parent is living in the United States with inspection, living in the United States without inspection, and living outside the United States. First, the parent living in the United States with inspection means that the parent must have entered with some type of temporary legal visa. In most cases, it's going to be a tourist visa. They come here to visit their child. And while they're visiting the child, sometimes the parents have a change of heart. And they say, well, maybe I'd like to live here. Do you think you can immigrate me? Let's go talk to a lawyer. Let's see what's possible. In that situation, the entry was totally legal. The intent of the parent was to visit. It's transformed, and that's the adjustment. They want to become a permanent resident. However, you have to contrast that with a different situation where some parents come into the United States and they talk things over with their child already, and they are coming in with the purpose of becoming a permanent resident, of filing for permanent residency, of filing an I-130 alien relative petition. That runs into a question of fraudulent intent at the time of entry. That could lead to serious problems and permanently bar the parent from ever becoming a legal resident of the United States. So, and sometimes, parents come in and they say, I want to become a citizen, I want to become a permanent resident, but I also want to go back home. That's going to be the situation number three, where they're living abroad. We'll get to that in a second. So, what happens with those parents who have come into the United States without permission and they want to be immigrated by a child that was born here in the United States or that naturalized and became a citizen? Well, the problem there is, if the parent has lived here over 180 days, they're going to run into the immigration bars, the 3 and 10-year bars. They're going to have to go home through the process that we call consular processing and a tendered interview in their home country. In most cases, they're going to need to file for a waiver, an inadmissibility waiver, often called an I-601 waiver. That waiver is based on a concept of extreme hardship. Extreme hardship to whom? Extreme hardship to a qualifying relative. Well, who counts as a qualifying relative? A United States citizen or permanent resident, spouse, or parent of the immigrant seeking permanent residency benefits. That means the child who has filed the petition to immigrate their parents does not count as a qualifying relative for purposes of the waiver. That can raise some serious problems for a simple reason. If a parent of an immigrant or a spouse of an immigrant had is filing to be considered the qualifying relative of that person, then why didn't they file the I-130 for that person on their own? The odds of someone being a qualifying relative that hasn't previously filed an I-130 petition for that person is slim. Therefore, the issue of qualifying relatives may preclude a lot of families from seeking to immigrate their parents through the consular processing method. Now, there is a possibility in some cases that the parent or the spouse of the immigrant seeking green card benefits will meet the qualification of a qualified relative. In some cases, perhaps, the parent of the immigrant may have passed away, or the spouse of the immigrant may have divorced the immigrant. They had filed an original petition, but they never finished the green card process. And so that immigrant has been left high and dry until their U.S. citizen child now seeks to immigrate them. In that case, the earlier petition could possibly help the immigrant seeking permanent residency benefits under a concept that lawyers call grandfathering. There are certain dates involved, and then there's other requirements that will be involved in order for that immigrant to stay here in the United States and adjust their status to green card holder. In those situations, I would almost always recommend that you discuss your situation with a local immigration attorney to make sure that everything is okay and that you won't go to the interview and run into problems. Now, the reason for that is this is an area that's ripe for fraud by scammers. I had an individual recently who came to my office who had went to his green card interview here in the United States, who had entered way back when legally with a tourist visa, but then went home and then came back later, subsequently, years later, without a tourist visa, came in without permission. They went somewhere for immigration assistance, the wife and the immigrant spouse, and they were told that they could adjust status here in the United States based on the original entry, which was legal. Well, that's not true. The person had left the United States on time, had not overstayed, and yes, that was legitimate. However, when they came back without permission. So they went to the interview. And at the interview, the officer told them straight out, you do not qualify to adjust status. We're going to deny this application, and we're going to refer you to immigration court because you're living in the United States as an undocumented immigrant without permission to reside here. In other words, the person who had assisted them had led them down the wrong path and either did not know the law or committed outright immigration fraud. I tend to think it was the former because these individuals were charged the outrageous sum of $14,000. I think they were duped, and the person who led them down the wrong path knew what they were doing. And this is a problem for a lot of individuals who don't understand the differences between what qualifies someone to go to an interview here and what doesn't qualify them. It's an issue that you have to be very careful about. Well, let's talk about the third situation. The third situation is the immigrants living abroad. For instance, the parent who came in, visited their child and said, I want to become a permanent resident, can you help me? And then they return home within the 6 months period of the visitor's visa. They're clear. Or the parent who has never even come into the United States. That's the classic, clean, clear consular processing situation. In that case, the child will file the I-130 alien relative petition for their parent, and they will process everything through the embassy or the consulate abroad. Now, 2 points before I close here. One is the situation, if the parent that the child is trying to immigrate is a step parent or an adopted parent, there are some additional requirements, and those need to be carefully considered in terms of when the relationship began, how close was the relationship, and related matters. The second thing is, and it's it goes back to the situation of the parent that's living here without permission. That is the situation that immigration opponents love to call anchor babies. But as the brief description that I gave a few minutes ago shows, there are very few situations where someone's going to come into the United States just to give birth, wait 21 years, then go abroad, go through the consular processing system, which could take 5 years, 10 years. It takes 30 years for them to become a green card holder. The whole anchor baby argument, and this is an aside, is falsely made just to scare people away from becoming permanent residents. Now, I do say this though, be careful if you're in that situation, because as this one individual who paid $14,000, they end up hoping for a green card, and instead they find themselves on the verge of facing deportation proceedings in immigration court. With that, I wish you the best of luck. I wish you and your family all the good luck in the world, and I hope one day that you not only become a permanent resident, or that your parent become a permanent resident, and that they go forward to become a full-fledged citizen. Take care and good luck. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below, or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time, and hopefully we'll be talking again very, very soon.